today. We're going to talk about billing guidelines and how to enforce billing guidelines, and going to give some real life examples of some billing errors and talk about how we can prevent those. If you guys have any questions, please feel free to chat in the chat box. Or if you want to speak up and we can engage directly, that would be fantastic. My name is Virginia Griffith, and I'm the Vice President of Business Development at Legal Bill Review. And I have from my team, Wendy Roberts, who is our VP of Legal Analytics. And Wendy does our opportunity assessments, our bill review, manages our bill review team. And Patrick Fuller is with us. He's VP and General Manager at ALM Intelligence. And Lourdes Slater is the CEO of Karta Legal. So the goal today is really to make this as interactive as possible. And I'd like to start with kind of giving a big picture about why law firm billing is an issue and why should we care about it, and where we see it going over the next year or so, especially as rates are increasing, as there's a war on talent in legal and quite frankly everywhere in the country. And Patrick, I'm sure that ALM has the latest and greatest statistics on what's going on in the law firm world with rates and billing requirements.
Yeah, no, we do. And it's, you know, the reality of it is rates continue to rise. They rose through the pandemic. The, you know, cost of doing business and the cost for talent, you know, continues to increase. And so rates are going to continue to increase. And quite frankly, you know, we got into a period during the pandemic and the initial stages of the pandemic where there was a lot of demand that was what we refer to as unknown or reactive demand. That, you know, a couple of byproducts that happened is, you know, a lot of legal departments that normally might have looked for alternative counsels or, you know, smaller firms to handle certain types of matters, and they would right size the matter to the firm. Instead, we're just kind of going to their, you know, whether it's panel counsel or trusted counsel, and just saying, hey, we've got this issue. You have somebody that can handle this. And there wasn't the oversight that normally would take place. Firms continue to push rates through. You know, you're going to continue to see that 3 to 6% rate increase again this year. And, you know, the gains that we're seeing in some of the metrics are largely driven by rate increases, right? The volume of legal work and demand continues to stay relatively stagnant, increasing in certain areas. Rates will increase. And, you know, especially for some of the smaller firms that shed a little bit of headcount during that period, you're going to see, you know, some of the metrics like productivity and RPL increase in those firms because there's fewer fee earners in some cases handling more work. So the metrics will be a little bit inflated through that, but largely it's going to continue to be driven by rates.
Well, and Patrick, I've been reading a lot about Milbank and some of the other New York firms and their associate rates, and the associate rates increasing to the highest point ever.
Yeah, I mean, and that's, again, but that's going to continue to happen regardless. I mean, 7-8 years ago, you would see cities in the Midwest that were amongst the greatest in terms of associate rate increases. That will continue to happen. You know, the cost for associates is continuing to increase for some firms, and it's also, you know, associates can be some of your most profitable timekeepers as well too. And so, you know, raising the rates even a little bit on associates at that point when there's 65%, in some cases 65% of the time being billed on certain types of matters. Yeah, you want to be able to maximize your earning potential in those areas.
Lourdes, what are you seeing from your clients, both on the law firm side and on the corporate side, with regard to billing requirements and, you know, the rate increases going up and kind of pushing on those billing requirements?
Well, that's a very complex question, because I think the billing increase sort of highlights a bigger problem that we saw during the pandemic, which is there is a lot of talent leaving law firms, right? After being at home for a year or two and dealing with the demands from home, et cetera, there was a huge sort of exodus of talent. And that is now, we are trying to replace that. And that sort of, highlights why associates rates may be going up as well. Our in-house department clients are not very happy about the increase in fees. I think a lot of them do not understand the basis for it, other than this explanation that there is a war in talent. So everyone, resources are more expensive. So I think there's sort of like a conflict of interest between the in-house counsel and what they think they need and what the law firms think they need to make sure that they retain and acquire the right talent for these cases. But it's sort of, the dust really hasn't settled yet on what that all means. I know that we talk about, this war on talent, but I think we have to really talk about what has happened to the industry over the last 2 years in terms of the talent that we have lost. And I think some of my clients are really focused on with the new sort of the shift in resources and associates and partners, what is that doing to the diversity numbers that they are so keen in sort of, improving and increasing. So all of that is sort of in the mix of what we're going to discuss today.
And are we seeing that corporations are pushing back on the law firms with regard to their increase in rates, and how are the law firms responding? And then we can kind of start to dive into some specifics.
I think that's a very individual question. I think that most of my clients are really focused this year on updating or acquiring outside counsel guidelines. A lot of them are really outdated. So that has to sort of, be part of the conversation. A lot of them are also trying to encourage even the smaller firms to use e-billing systems. A lot of these firms do not yet have that. So that is sort of, a path to success and improvement right there. And I think there is sort of this idea that once if you have billing hygiene and if you have the right guidelines in place, that training and adhering to those guidelines will sort of control this runaway train about outside counsel fees. I think one thing that is top of mind for all of my clients is allocating the work to the right resource, meaning not have partners hoarding hours and not have associates doing paralegal work and not have paralegals doing clerical work. And that is something that can be sort of spell out pretty clearly in outside counsel guidelines and sort of, executed by the proper review process.
Lourdes, I imagine you've seen this too, and Wendy, you've seen this as well, where you've seen partners doing paralegal work. And, I know I've seen it in my past as well, where, the outside counsel guidelines would state that we're going to, certain phases, certain tasks within certain phases are going to be, should be handled by paralegals or by legal assistants. And, I remember talking to some in-house lawyers who were shaking their head at the fact that partners from these firms were doing that work, but then billing the paralegal or the legal assistant rate and thinking that they were providing greater value through that, which is always a little bit mystifying to me, because the guidelines are being set forth for a reason in through there, and it wasn't for the firms to lose money in those areas.
And I think, Patrick, a lot of that, and we've seen a lot of that over the last 2 years, and probably Wendy can sort of talk a little bit more about this, but when we started working remotely, which was sort of something that was unexpected, the allocation of work and the communication between the teams was probably not the best and not what you were used to seeing, which meant that a lot of partners end up doing work, not because they, in that case, wanted to hoard the hours, but just because they needed things done. And the systems were not already in place, right? Without the proper legal project management team in place, a lot of things can fall through the cracks, which ended up sort of costing a lot of misallocation of work and partners doing associate work, et cetera, et cetera. And I think there has been some kind of the in-house counsel, they understood that, and there was some leniency towards that activity at the beginning, mostly because of necessity. But I think by now clients should expect better, and really going through, making sure that their guidelines are being followed accordingly. Something that we may want to talk about now or later is that entire notion of the in-house counsel and outside counsel relationship, which oftentimes comes from a place of trust, that trusted advisor concept, and makes it very uncomfortable sometimes to have those discussions. I think a lot of times in-house counsel want to justify what their outside counsel does because their outside counsel has been chosen by them, for other reasons. It could be, law school friends, it could be some network connections there, or it could be that they've done really good work in the past for them in other cases. So that relationship is very delicate and I think needs to be managed accordingly. But when you really, when it comes down to it, and there are, many studies and reports and law review articles and statistics, including a recent one that I read from the California State Bar, that most bills are inflated at least 10 to 30%. So in-house counsel may want to justify that somehow. And you really have to sort of sit back and talk to, I talk to both my law firm clients and my in-house counsel clients about this idea of, your ethical and your professional duties to the company. The fact that an in-house counsel may want to preserve a relationship for whatever reasons, sometimes really valid reasons, it doesn't take away from the fact that they are ethically and professionally obligated to provide their corporation, i.e. their client, the best service that they can. And sometimes I do not see that happening.
Oh, I agree. And I definitely want to bring Wendy in here because this is a conversation that we have frequently. Part of what Wendy's role is with legal bill review is helping us out when we do the sample reviews for potential clients. And Wendy does those bill reviews. And that's when the conversation often comes up about the relationship and what is my law firm going to say if I question, these. I mean, we've had people even tell us, I don't want to squeeze blood out of a turnip. Wendy's got a few, really good examples of that.
Yeah. So I am, I guess I'll use, the legal term flabbergasted that, that in-house counsel is so concerned about preserving the relationship, which of course bill reviewers are as well, but it seems often quite one-sided. The law firm should have an equal interest in preserving the relationship in the form of accurate billing. So we often talk on our team about how the OCGs, although they provide a framework, there's the overarching umbrella that lawyers are bound. They have an ethical duty to perform the best service and get the best rate and check their bills and not overbill. And that applies both to in-house counsel and outside legal counsel. So we do often talk about that. Lourdes mentioned, during COVID, the things that we saw being billed, and we saw many instances of lawyers and I can picture them sitting in their home office performing administrative and paralegal or lower rate staff tasks just to get them done. We also saw an uptick in communication being billed for between the lawyer and their admin or their paralegal, which normally I would imagine would happen while sitting in their office and yelling out the door, "Hey, can you get somebody on the phone?" or whatever that was to be. So we did see those things. And I do believe that it was a matter of we were working with the best system we could immediately come up with in the these unprecedented circumstances. So the relationship goes both ways. And that ethical duty is not something a lawyer, no matter what position they're in, can sidestep. So I'm always interested about who's the more concerned about those relationships.
Peter asked a really great question about, and I think if I understand him correctly, he's asking if bringing more things in-house is counterbalancing the rates. And if that's, a trend that we see to offset some of the rate increases that the firms are taking. Patrick, Lourdes, do you guys want to speak to that?
I think Lourdes and I could probably speak to it from different angles, just from different experiences. I think there's parts of that in there where technology is making it a little bit easier, and the firm, there are certain types of matters and repetitive knowledge tasks and that type of thing that's better suited to automation and technology. That doesn't always align with the firm's pricing strategy, doesn't always align with compensation, and behavioral drivers and compensation plans. And so some of that work is better suited in-house or going to ALSPs and, some of those carriers. I think there will continue to be a lot of work that simply will go to law firms and outside providers from a, how do I say this gently, sort of a CYA component. So not just the bet the business or bet the bonus types of work, but even some of the run the company types of matters will continue going to outside firms for the simple task that, it's the fully loaded cost to bring additional headcount into the legal department may not align with the budget that they have or some of the other expenditures. It's easier to outsource it to law firms. The trick is going to be, and we can talk about some of this, going on too. The trick is always going to be is to be able to route that work into timekeepers and firms and markets where it aligns to the matter type. So I don't, Lourdes, I know you have thoughts on that as well too.
No, I agree with everything you just said. I think that's exactly how I would have answered that question. Just to add a little bit, I think that every single in-house legal department, whether it is mid-size, even small or large, should be asking themselves this question, because I think there is a lot of high volume and non-complex work that perhaps has been sent to law firms before that now could be really handled pretty easily with the right technology in-house or outsourced with a temporary staffing type setting. I think you have to analyze what your particular situation is and what your process is and what the cost of both scenarios look like to make an informed decision. But definitely, I think that this is a way to lower outside counsel legal spend pretty easily. And I think it really should be top of mind as well for all legal departments.
I think, Virginia, one of the things, and I know we talked about a little briefly, that falls in line with this is going to be really interesting to watch. And it's going to be kind of fascinating how it's handled through outside counsel guidelines as well, is what we're seeing with expansion now, because historically, there's a couple of different layers to this, right? Historically, when firms would expand, they would have physical offices in these locations. And what we've seen, and you alluded in the opening to the war for talent, and one of the things that we've seen is really large firms going into markets and they're hiring associates away from, some of the smaller large firms or large mid-sized firms, or however you fit into that middle there, where they're working from home. And, there's significant bonuses that are, sign-on bonuses, and comp is being raised, and that they're going to, they're going to work, right? They're going to work. But the question becomes then is, how are you billing them out? Right? Because, one of the things that we would look at is like, oh, you're putting an office in Dallas, you're putting an office in Charlotte, or some, Richmond, or one of those areas where you look at it and you say, okay, the market rates in those areas would tell us that we want to route certain types of tasks, certain types of matters to professionals in lower cost markets. There was a thing that we used to run at Time Metrics where we would do this in demonstrations where we would show 4th and 5th year associates at AmLaw 100 firms for, commercial litigation or commercial transactions at a higher rate structure than 20-year partners in AmLaw 200 firms. So 100 to 200 in the Atlanta and the Charlotte area. Right. And so it was, you start going down into those lower cost markets, and there is an expectation from the buy side that we are going to get into lower cost resources. So there's two things that are happening. So one, I mentioned you've got law firms now that are hiring remote workers in these lower cost markets. So it's going to be interesting to see what they're billing them out at, especially since they're making fairly aggressive recruiting pitches for them. The second part, though, is you also see a lot of large firms now moving into really smaller markets. And so, we saw Kirkland and Latham, or Wilson Sonsini moved into Salt Lake City, which is a really good market for startups and IP work. A number of firms moved into Austin. And you're hearing rumblings of firms going into Raleigh, Durham, and Charlotte, and some of these other areas. The question becomes is, are these markets really suited to support the rate structure that the firm has? Are you going to be able to have that level of consistency within timekeepers, or is the expectation of the clients, is this set up in such a way that the firm is expecting to have this pushback from clients around rates, and they are specifically establishing some of these markets as lower cost resources that they can push a lot of this work down to, still maintain profitability levels, but have lower total matter costs? And so I think that's going to be something that's kind of fascinating to watch moving forward.
It is fascinating, and it would be fascinating if, as a client, you are hiring a local law firm, and you have your star associates billing at $300 or $400 an hour, and all of a sudden they start working for Kirkland, and the rate for the same person just doubles. How does that work, right? How is that explained to the client? How is that justified? And those are the types of discussions that I think in-house counsel needs to be having now, because with this remote working situation that I don't think, even if we go hybrid, it's never going to go back to the way that we were. There is a lot of flexibility or possibilities for in-house counsel to really have pricing and rate discussions with firms that have gone into those markets. And it depends on the firm, right? I think some firms that have, offices everywhere, they charge different rates for different markets, and that makes sense. And that's sort of the way they've always done it, because they're more of a regional types of firms. But how does that work now? It's a very good question.
What I'd like to do next is get into some real specific examples of billing errors and the types of guidelines that could be introduced to prevent those billing errors, or how to remediate those billing errors. We really see in Lourdes that the California study, we cite to that a lot in our bill review. And typically there are about 5 major categories that we see billing errors. from bill padding, which, we can also call as block billing. There's simple time math errors, the lower staff task, which we talked already about, in particular with COVID, vague descriptions, which is always one of the most interesting, and then lawyer training. Stephanie, would you bring up the first slide? Stephanie, are you able to get that PowerPoint slide for us?
Yeah, I'm getting it up.
Thank you. And what we're going to do here is we've actually taken some real life examples. Of course, I took any details out of them that would, tell us who they were from or who they were about. But, the goal here is to kind of show you the types of things that we actually see on invoices, and, what the problem with that is, and what kind of solution there might be to this. So Wendy, will you go ahead and tell us a little bit about this particular example and give the story behind it?
Sure. So in this example, and this is from 2020. So into 2021, COVID had shut the world down in April of 2020. And although the world was shut down, and in every court system, there would have been a pretty public announcement that the court system was starting back up. And certainly it was clear, or should have been clear to everyone, that, jury trials were not going to be the first thing to begin again because of social distancing and so on. There was a law firm who dragged a file out, and 18 times in the 11 months between mid 2020 and mid 2021, a lawyer billed their client to make revisions to voir dire and opening statements. There were some other entries that this attorney made, during which they were working on closings and things like that. And although I understand, that you'd want to perhaps keep things fresh in your mind, this was not an appropriate spend of time when, for the following 11 months after the first entry, the court system wasn't even open. So this was unnecessary work. It's not something that should have been worked on. It was worked on by a senior attorney, and just simply not a good spend for the client.
And Chip, that's a great question. 1.1 hours billed by the senior attorney every time. I think that's the way it was written, right, Wendy?
Yes.
It was the same exact entry every time.
Yeah.
So we flagged it as unnecessary work, duplicative work. There were several issues. Lourdes, how would you address this from a billing guideline standpoint?
This goes so far beyond a billing guideline point, right? But let's not talk about, fraud or sanctions right now. Let's just talk about how this could be avoided. And I think, when we work in billing guidelines, we really talk about tracking the budget and doing the work that is needed per the phase that we are in, right? So, a litigation, for example, the ultimate goal of a litigation is either settle or go into trial. So a preparation to trial is something that happens in every phase in a very sort of abstract way. But you do not prepare for voir dire until you are ready to go to trial. So the fact that there was no trial ongoing, to me, this would have been caught in some kind of guideline requirement that the work be done at the right time, the right level of attorney expertise is required at the right time, pursuant to the budget and the phases of the case. And that would sort of prevent things like this from happening, because the pre-trial and trial work happens very later in any of our litigations, for example. So that's a way to do that. And again, I think that this also goes to the point or the billing guideline requirement that work has to be done only as necessary. This does not seem to be necessary work right now. So that also would cover, this particular issue. Of course, the bigger question is, what type of lawyer training the law firm is providing for their timekeepers, which really doesn't happen enough and should happen all the time, not only to your new timekeepers, but at least once a year to everyone, to make sure that things like this don't happen, and really call people out on it. I think that a lot of times, these things just get pushed under the carpet, which again, I think is neither professionally not ethically acceptable in any way, shape, or form.
And from the corporate client standpoint, we often hear, well, I want them to stay refreshed on the case, or I want them to, touch base, that kind of thing. But this is clearly something that they should feel comfortable pushing back on, or having their third-party review company push back and say, hey, this should have happened once, not 11 times or 18 times or whatever it was.
There's something that we don't talk about that much, but there is case law out there that is pretty scary when it comes down to this whole sort of mix between in-house and outside counsel. I think there is a case, if I remember correctly, perhaps from Georgia, not that long ago, that basically implicates the corporate officer or in-house counsel in a law firm's billing fraud type of case, because in this case, if I remember correctly, the particular lawyer that was accused of improper billing was billing always with 1 hour increments, and it was so blatant that the court not only sanctioned the outside counsel but also in-house counsel. So this is something to be really taken seriously.
Yeah, that's a really great point. I've seen that case as well, Lourdes, and I know it's something that we're, diving into more and more with our clients, what their responsibility can be legally for not managing the bill review process. Patrick, did you have a comment?
We could do an 18-hour webinar on some of the stuff that we've all seen in bills. It just sort of makes you scratch your head and go, why? But it's one of the things that you run into is that they've got the brazenness that you see sometimes is evidence that they've gotten away with it so much previously that it's not even a second thought anymore. And that's the thing that sometimes is a little bit scary. I'm curious in this example, Wendy, I wanted to ask you, was because one of the things that you would see with these too, which sometimes this is the benefit of having human eyes on some of this, is that it's not always entered with the same UTBMS code, right? So this could all go into L710, but it could also go into the L100 side. It can go, so they can enter in this same line item here, but they can do it under different task codes, which is also going to throw off, for me, it would always throw off the data, right? It would absolutely corrupt the data at that point, because you knew that the line item description didn't match the task code that it was associated with, which was always a dead giveaway as well, that something was going on.
Yeah, and Wendy, feel free to explain how you discovered this, because this is certainly not something that that a software would have found. This was a matter of Wendy. I'll let you tell how you discovered this.
Yeah, so I have the benefit of seeing previous bills that I've previously reviewed. As I'm going forward, I can refer back to the things that I look at. Much of it is simply, a human being's recollection that I think I've seen this before, and this looks very familiar. I have the benefit of being able to sort things in any way I choose, and can come up with things like this. The 1.1 hours, we have a category that we call improbable time entry, and it's improbable that this lawyer spent on this crazy task 1.1 hours every time. Recently, we had another one, which was, I think, let's call it 100 entries, and something like 20% of them were billed at 1.9 hours. I'm not a mathematician, but the probability of that being true is incredibly slim. But the way I look at it is, it's a way to keep it under 2 hours, and perhaps, somebody who's looking at it really only looks at the higher increment entries. So by having my eyes, an attorney's eyes on the bills, I do have the ability to see some of these things, and I can look back into a previous month and just sort of refresh my recollection with regard to what's going on. But and interestingly, my recollection is not much happened, because nothing was happening in between these entries. So honestly, there weren't a ton of entries for me to pick this out of. This was almost the only thing that was happening on this case, but it was a way to have some sort of a bill each month.
I think that eyes on your time entries before it goes out to the client is essential, and law firms should have that. Barring that, or having eyes that are not that particularly detail oriented, nothing really beats having a company like yours go through these invoices. And even if you think that the padding, or however you want to call it, is de minimis, think about whether or not, I'm not a mathematician either, but if you have one timekeeper at a pretty expensive hourly rate, billing 0.1 of an hour every day or every other day for a whole year, that could be anywhere between $10,000 to $25,000 in unearned fees in a single year, right? Depending on the lawyer's billing rate. So it adds up very, very quickly. And the 1 hour increments are brutal. They're easier to catch, but the little 0.1s are the killers.
Stephanie, can you move to the next slide? So this example, we picked this example for a couple of different reasons, but I think the important point here is to make sure that there are billing guidelines to prevent a $705 an hour attorney billing 4.3 hours for legal research, and part of this is block billing, because that was the only narrative that we had on this particular line item, was legal research and response. And Wendy, tell a little bit more about this, and then what types of things do you, Patrick and Lourdes, see as problems with this, and how do you prevent these types of things?
So and again, sometimes I can cobble together exactly what research is being done, but first pass research generally should not be performed by a $705 an hour attorney. Depending on the complexity of the research, you might see a higher rate attorney performing that research, but generally I would expect to see a lower rate attorney performing the research, that research can then be more quickly reviewed by a higher rate timekeeper, and drafting the response. Certainly many responses, not all, but many responses are at least in part forms, which every attorney should have access to, but certainly a lower rate attorney can get started. In this situation, I'd want to know how much time was spent doing the legal research and how much time was spent drafting. Ideally, there would be an amount of time after the legal research, and then the rest of the 4.3 hours listed after the draft response, so that someone can ascertain whether an appropriate amount of legal research was being done. We've seen many situations in which there's an extraordinary amount of time, hours and hours spent research and drafting, and then it's bumped up to a higher rate attorney who should be reviewing. However, often or sometimes that higher rate attorney is spending as much time reviewing the document as the preparer. And what that tells me is that one of two things is happening. Either the reviewer is spending too much time, and that would be tagged for excessive time, or the person who was originally assigned the task was not equipped to adequately and efficiently handle that task, and it should have been assigned to someone else. So these are all of those relationships we're looking at. But when we're faced with something that simply says legal research and draft response, I don't know what that means, and the client will not know what that means in many circumstances. And a lawyer has an obligation to be clear in their contact with their client, and that of course would include in their bills.
And I think the ABA standards are that both a client and the court, and a court should be able to tell what was done and how much time. Lourdes, do you have any thoughts? Oh, you're on mute, Lourdes.
My dogs were barking. First of all, as the partner at my law firm doing, the review of the pre-bill before it goes out to the client, this would have never gone to the client, right? Because this would have been rejected by all of my clients' billing guidelines. There is no way that a 705-hour attorney is doing legal research without explaining what that is, unless it's extremely complex and derivatives or something equally niche. And because the block billing between the research and the draft responses combined, it would have been automatically rejected. So this would have never been paid, period. So that's what I have to say about this. I mean, it's just, if you had 4.3 hours billed by the same attorney for legal research, perhaps the guidelines would allow to build this at a paralegal rate or a first or second year associate rate and automatically make that adjustment and let it be. The problem with this particular one is the combination between the two that makes it totally, not pass the test at all. So this would have been rejected.
Great explanation. Stephanie, you want to go to the next, the last one? And again, the goal here is just to provide some real life examples. These are things that we saw in invoices that our team reviewed. And Wendy, I will let you talk to this one. This is actually one of my favorite ones because I know there's software that actually does this. So.
And I mean, even if the software isn't being used, certainly a senior attorney does not need to be once a month for 8 months checking the docket and trial dates. And again, this is a situation that just happened to come up during COVID, but there are many similar situations that happen independently of any, worldwide pandemic. I'm pretty certain that this lawyer would be put on notice in some way if their court system was suddenly open for business again. So there should be no need to check the docket 8 times, but certainly a senior attorney shouldn't be checking the docket and for trial dates 8 separate times. This is something that, an admin should be doing, probably not even a billable task. It's incredible. And quite frankly, it also shouldn't take 0.2 hours a time. I mean, once you've checked it 2 or 3 times, certainly you should be able to, even if it requires logging in, it's certainly something that should be a really quick task, definitely not undertaken. If there's the need for it to be done each month, it should not be undertaken by a senior attorney. It's just crazy.
And most law firms have docket clerks that take care of this kind of stuff and put things on everybody's calendars, correct?
Exactly. Well, according to the U.S. Supreme Court, Missouri v. Jenkins, I believe 1989, purely clerical or secretarial tasks should not be billed at paralegal rates even. So this would not be an entry that is billable at all.
Lourdes and Patrick, what can the law firms do to prevent this? Lourdes, you talked about how your firm, this would never have gotten to the point that it was on an invoice and going to the client. Never.
Because we have a process in place where our bills are reviewed very properly before they go to the client, right? To us, our time entries and the bill to the client, it is not only work product, but sort of reporting on our performance and how good we are. And we stand by everything that goes out. So I think that law firms should have systems in place where things like this do not leave the door. Many firms will not have the resources or the ability or the training to do this type of process in-house, which leaves it to in-house counsel to do this. And in-house counsel is not only overworked, but they do not have the tools to really go into this time entry review process in any way that is accurate enough that I would feel that an in-house counsel will be able to tell the board or the business unit that these are all proper bills. So I think that creating a process, both the client and the law firm should talk, but creating processes and requiring processes that the law firm should have in place, having the proper guidelines, and also sort of figuring out what as an in-house counsel you can do to do your job and not pay bills that are 10 to 30% inaccurate is sort of a must do. And having a third-party reviewer is certainly a very smart way of going about doing this.
And Patrick, from a business perspective, if you're the corporate client, I would assume that your CEO, your CFO they don't want your GCs and your in-house attorneys doing bill review. They're not paying them to do bill review.
No, I mean, like everything else, the higher you get in the organization, the more you want to have a strategic role and not a tactical role in things. So you want to make sure that you are, I don't want to say outsourcing to some degree, but you're, whether it's outsourcing or whether it's pushing the work down. I mean, the one area where most people get to the strategic is by learning how to execute on the tactical, right? So it is a sort of a rite of passage and a learning opportunity. Why is this an issue? I mean, I'm still kind of laughing at the incredulousness of $1,400 to check on docket timing over the course of 8 months. I mean, I don't know if it's the rate or the 0.2 hours each time. The fact that it took 12 minutes each time, I'm still a little bit, I'd hate to see what the bill was in that if they were opening a can of soup, it might be 0.4. because I think that involves a few more steps. But I think that's the sort of stuff that's so brazen, that's problematic in through there. And when you have, and you have to dig through those bills. One of my friends, Deborah McMurray, she used to do a program for marketers called Couch Money. And it was really about looking through a lot of the invoices and the spend and the contracts that you have to be able to right size them and whittle them down and everything. And, to find the hidden sort of dollars in your budget in through there. And it's the same thing with legal departments, right? You got to reduce your spend. Well, part of it is you want to be able to look for areas where it's low hanging fruit and it's easily you can easily reduce it. The reality of it is, though, it's also a time and value issue at that point, right? Because you have limited time. It's the most precious resource. We have 8,750 hours a year of breathable time. How much of that are you going to devote to looking through bills that should be, from a professional perspective? And to Lourdes's point, it should never have it should never have survived past Prebill. In that area, you're paying a lot of money for that level of professionalism as well. And, there is an expectation in through there that it should be coming to you with the same manner and care, Lourdes, that your firm does, right? I mean, that should be expected. It's almost like, I don't know. I think we've gotten to the point sometimes where we thank people when they return a wallet full of cash, like, wow, you went above and beyond, when it should be the very minimal that's expected. Right. And so, I don't know, I struggle with some of that stuff, because to me, it's, and Virginia, you know me really well, and I read too much into everything. But if I've got to question you on that, how can I trust anything else that you're saying?
Well, and to even make that more simple, this is a communication from the law firm to their client. And if everybody treated the invoices as a communication to the client, I think that would help in so many ways.
Well, it's a record of what you've done and how you've done it in many ways, and how you value it. But it's also germane to the amount in controversy, for example, litigation. You're not going to treat a $50,000 matter the same way you're going to a $50 million matter. And, part of it is, that you're right sizing the strategy to the risk associated with it and the risk that's posed. And, that unfortunately that doesn't always happen, but that's one of the reasons why you put the checks and balances in place. And one of the reasons why you take the time, and let's be honest, right? We're talking about outside counsel guidelines. This isn't something that you can just write up on the plane sometimes. I mean, it takes time to put these together, and, there's a thoughtful approach to doing it, and doing it the right way, and understanding, how it's going to work within the framework of your outside counsel, what's in align with what you're trying to do as a legal department and the goals you're trying to achieve. And you expect that to be followed. And that should be the very minimum that you should expect.
It's one of the things that we do with our clients almost 100% of the time, is if they don't already have outside counsel guidelines in place, we help them develop those and get those in place, so that again, at a minimum, we're following the guidelines.
And not only have the guidelines in place, but train your lawyers. And that is something that is a must do. And I think a lot of companies, even if they have the best guidelines ever, they just hand them down without sort of proper training of what that means, and sort of making sure that that is done for every employee and every timekeeper, and maybe do it every year. It's very important to do that training, people training component. So it's what we always talk about: people, process, technology.
Yeah, and it, Lourdes, to that point, it drives me through the roof that especially with larger firms with greater resources, that this is something that should be done at the practice development or practice management level, should be done by the lawyers, yes, but also from a client relations perspective, the metrics that law firms track don't always, in fact, rarely align with the same metrics that their clients are tracking. And most of what the clients are tracking are rooted around what's in the bills. So it behooves you at that point to understand what the expectations are, right? The BD managers at firms, and I will die on this hill. They should know for their key clients, they should know what the outside counsel guidelines are. They should understand what the billing hygiene is. They should make sure that they're aligning with the expectations of the client, because when they go in to do client feedback interviews, I can guarantee you, and you guys have done this, that they're going to have scorecards, or they're going to have a record of the billing hygiene. You know, that's one of the things that they're going to ding the firm around. And if you're bad at the hygiene and you're bad at client service and communication and things along those lines, that doesn't bode well for growth. And that's the whole idea behind this, is to get deeper and wider with existing clients. It's easier and more profitable to grow revenue with existing clients. And so if you know that they're checking and they're focused on the billing hygiene, and they're, you know, that's a big issue for them, your first question should be, what can we do to make your job easier and make sure that you're making your bonus? How can we do this more efficiently and effectively to make you look good and take this worry and this risk away from you? It's good business.
Patrick, I think that's a great note to end on. So we'll leave you on the hill that you're going to die on. We do have a couple minutes if anybody has any questions. Part of the reason that we do these is so that we can put the webinar up for people to review and refer to in the future. So I appreciate everybody joining us and your thoughts today. And if there are any questions, please feel free to chat. Yes, you can get a recording. Absolutely.